of assault. Let's hear now what Section 29 says. Reporting obligations and cooperations by members. Section 29, subsection 1. The station commander or any member of South African Police Service or Municipal Police Service must, paragraph A, subparagraph A, immediately after becoming aware, notify the Directorate of any matters referred to in Section 28(1)A to F, which includes F, which I've referred to as well. So it means any member, and by any member, I'm now referring to you, Brigadier Geninda, that after receiving that complaint in terms of this act, this is what we are supposed to do, to report the complaint to the Independent Directorate, Police Investigative Directorate, to investigate the complaint which was made by the accused in court. Did you do that?
My Lord, this section that I read refers to a complaint. My understanding, it's a formal complaint, not information or someone sitting there and saying, this is what I'm saying. I've testified, my Lord, that there were steps that I took and clear directive that such complaint in terms of the facts were occurred to be done. Matters that get registered today.
Brigadier kuyabuzwa ukuthi wenzile lo Brigadier isikhalazo sikhuluma ngesikhalazo esisemthethweni ngishadokodo lilethwe ukuze nabo bazokwazi ukuphenya njengoba bakhuluma la ku section 28 no 29 wabo aba.
It does not.
When we were listening to that case number 2 on the 5th of March, is that not so?
Not on the 5th, on the 27th.
Is it on the 27th when this attorney came from his clients?
That was the 5th of March.
Yeah.
What is right?
Yes.
2021.
That they are being assaulted.
Correct.
Right?
Yes.
Let's play that, because then the magistrate said, "This, who's that? Mr. Ngumezulu?
That's the evidence.
That's it. And if you find or get any problems, the commissioner of police must be approached. I think the commissioner of police must be approached so that a formal complaint can be laid. Is that not so, sir?
That's the evidence.
When I was listening, now has that been done? Ms. Mshololo, you can, or you, Mr. Has that been done?
My Lord, may I just get clarity from what my colleague is asking?
We'll come to the IPID.
Yes.
I'm talking about
She was
what happened in court.
I'm not sure if that question relates to what happened in relation to accused number 1. Before we get into accused number 2.
Yes.
Because the first report that was made to the Brigadier in relation to the line of questioning relates to accused number 1.
At Silverton.
At Silverton.
What was the date?
The 10th of July, if I'm not
And was that report made in court?
The report was made in court to the presiding officer.
What was the date in court that day?
The 10th of July, if I'm not mistaken.
Is that so?
No. Not in Fosloras. I'm referring to, yes.
And that is a complaint regarding Silverton.
That's correct.
Right, because now Geninda is referring to that. As I understand you, you are referring to that complaint.
The one of Silverton, my Lord. I'm referring to the one of Silverton of the 10th of July.
Yeah.
The accused, all these measures were put into place, and he was not willing to make a statement. And no registers confirmed that he was assaulted.
Okay.
Futhi ke kuthiwa ku wonke lamaqala lawo bewafakiwe akukho la umangalelwa yena ayewazimisela ukwenza statement eshoyo ukuthi yebo ngishawe ubani nini kuphi.
Right, I'm sorry to interfere. But from my understanding, how do you lodge a complaint? Is it on affidavit or is it just verbal? There's no record of that.
My Lord, I think it would be unfair for me to be cross-examined by the court when I'm putting questions to the witness.
I'm not cross-examining you. I just want to understand the law.
May I then be given the opportunity to put questions to the witness?
No. Listen. I want to understand the law. You have given me this. As you say, that is the applicable law.
Yes.
And I want to understand, because From the record, it appears that the magistrate Avenga intervened to the attorney who was, is that not?
My lord, I'm not referring to that
Okay,
one.
okay, fine, go
Yes,
ahead. Okay,
I'm not
okay.
referring to that one.
All right, all right.
Yes.
Sorry about that.
I'm referring to the one that was made in Tembisa Court, my lord.
In Tembisa Court,
Yes, in Tembisa Court about Silverton police officers
okay, fine.
Yes,
On
that-
which day? You say it was on the 10th.
on the 10th of July.
Okay, fine, you can go on.
And that complaint, my lord, was made by accused number 2
Okay.
in full court. Oh, I'm sorry, my lord, accused number 1 in Tembisa, not accused number 2. On that day, the exhibit will clear the record, my lord. And about the police officers in Silverton. And then my next question is, my lord, with that complaint which was reported in a court of law, which was related to you, Brigadier, as the head of the unit, what did you do with that complaint? Because this act precisely says the complaint must be referred to the Inspectorate Police Investigative Directive for further investigation.
As a court case, my lord, I think my learned friend should have also made a copy of the regulations issued in terms of the IPID Act, because these regulations must be read in conjunction with the Act. Now, she's reading the Act in isolation, and if one looks at, I had a quick look at the regulations. For instance, Regulation 2 says reporting of matters to the investigating directorate. A station commander or any member of the South African Police or the Municipal Police Service must, say, within the period mentioned in Section 29(1)(b) that my learned friend has quoted, of the Act, submit a written report. A written report to the directorate regarding any matter listed in Section 28(1)(a). That is now the section that my learned colleague is busy with. And furthermore, Regulation 4(b), which is the most important one, says a person who lodges a complaint in terms of sub-regulation must do so in writing. By fax or electronic mail, and it says the provisions of sub-regulation 3 will then apply. So in other words, my lord, we say it's very dangerous to read the acts in isolation. It must be read in conjunction with the regulation, which makes it clear that a complaint must be in writing, as the witness has testified to.
Can I proceed, my lord?
Yes, I thought you were proceeding.
Thank you. Brigadier, I put it to you that if you had complied with the provisions of this section, and independent members of the IPID would have been appointed to approach the accused, obtain the necessary statement, and also to do further investigations.
No, but that's not correct, my lord. Counsel knows he was working for the state. You need to have A1, a complainant statement, to understand the allegation that has been made. What do I comply with when you don't have the existing A1 or any document or even an eyewitness who says I've witnessed such an assault?
Ngiyakwazisa ke ukuthi bekwamele njengoba kuye kwabanale sisikhalazo bekwamele labantu laba abaphenya amacala abazimele babizwe noma baziswe. Uthi ubrigadier uma iphendula uthi cha, kumele uyazi wayekade esebenzela umbuso, kwamele kube nestatement esibizwa i-A1, kuyistatement leso umuntu akhalaza khona ukuthi ngihlukunyeziwe.
Okay, I won't argue with you. I'll leave that one for argument. Let's proceed. Brigadier, I'm going to hand in, my lord, with the leave of the court, Exhibit XX, if I'm not mistaken. It was, if you can give the state one copy and the witness one copy. My lord, I did not prepare the copy for the court because we have used this exhibit. It's a statement regarding interview with suspect, my lord. It was marked Exhibit XX.
It's the one that was handed in by Mr. Mnisi.
Indeed, my lord.
Indeed, my lord, yes. That's why I did not make an additional copy, my lord. Thank you. Brigadier, I just want to refer you to few paragraphs of this pro forma. It's by SAPS. It's form number 3M in brackets, small letter M. Statement regarding interview with suspects. Okay. The reason why I'm referring you to this form is because you had interviews with suspects on different occasions. Do you understand?
I do, my lord.
Yes. Okay. And then, without wasting the court's time, paragraph 1, completion of statement. Okay? I'll ask you to read it to the court. Paragraph 1, subparagraph A, my lord.
So it reads as follows, my lord. The station commander must consult with the prosecutor on circumstances in which the prosecutor requires that a warning statement of a suspect be obtained in every such case. The suspect must be interviewed and this statement must be completed. This statement must be completed every time the suspect is interviewed, irrespective of whether the suspect has been arrested or not.
Okay, thank you. You understand that this form must be completed every time whenever there is an interview, irrespective of whether the suspect has been charged or not. That's the line I wanted to bring it to your attention.
Yes, but my lord, counsel is leaving something out important, that it said this form refers to that interview as directed by the prosecutor. It's a different scenario when the police, in no way does it refers to interviews of the police. It's very specific. You are directed by the prosecutor to obtain an explanation, and naturally, you communicate the outcome of the suspect in a form of a warning statement to the NPA, and that's what paragraph 1 says, my lord.
No, it doesn't say so. Let's read paragraph also, my lord, for the interpretation.
La aqeda kufunda khona ubrigadire ukuthwa uma abashushisi bathi amaphoyisa babuze abasolwa imibuzo kwamele kube nezinto ekuthi ziyagcwaliswa la. Uma ubrigadire ephendula uthi meli ungakhohlwa ukuthi la kuthiwa uma abashushisi, hayi ukuthi amaphoyisa behloma nje abamangalelwa imibuzo, kusuka kungabashushisi abatshele amaphoyisa ukuthi babuze abamangalelwa imibuzo.
Furthermore, my lord,
Paragraph
We've been down this road before when Sergeant Mokhane was testifying. I think we even quoted authorities and filed heads on this matter. It was debated. I think it's a matter that can be best left for argument, my lord.
I don't know how it impinges on a trial within a trial, because at this stage, this court is busy, seized with the exigency of a trial within a trial, which is a compact interlocutory process, which has its bearing as to whether any confession made by any of the accused or a witness, if there is a dispute that it was not freely and voluntarily made without coercion in a person's sane and sober senses, if a prima facie case is made by the prosecutor after having advised the court that he intends using that document, which is supposedly or allegedly a confession, then when the state has led that evidence, the accused themselves, if they so desire, they come with countervailing evidence to rebut the allegations by the state, which are laid down by its witnesses. This is what this process is about. It is not about the merits. But if you are saying this question you're asking relates to proving the admissibility and otherwise, no problem, you go ahead. But I've sang this song to say that this process we're in, it's about the admissibility of a confession. Okay.
My Lord, I will submit that the line of questioning regarding this form which I have referred the witness to, it's on the circumstances under which those statements were taken.
Yeah, fine.
It contains, my Lord.
No, you can go ahead.
Thank you, my Lord. Let's continue, Brigadier, with paragraph B.
Before, my Lord, we go to paragraph B, I wanted to bring it to the attention of the court that this form that counsel has referred me to is not a prescribed form. In other words, it's not the only warning. There are no prescribed form in the warning statement. So it's not a golden rule that this is the only way you must do it. Other forms are not, they don't even have this portion. So you have various warning statements, others that are even 2 or 3 pages long. So this is not the way. This is not the way that the standing order says, and it's regulated in the standing orders, my lords, to that effect.
Ngaphambi kokuthi singaqhubeka ithi ngicacise la ukuthi akusu ukuthi le form le ummeli anginike yona yodwa umthetho wodwa omile ukuthi kwamele na kanjani uma ubuza umsolwa imibuzo umbuze ngalendlela. Ikhona eminye imithetho eminye mide ukudlula le enginikwe yona, akusu ukuthi ile mthetho nemigomo ekwamele ilandelelwe kuphela.
Unfortunately, Brigadier, I'm the only one who is putting questions to you. I'm not going to argue with you with your line of questioning. The form I'm referring you to is the form that is prescribed by the SAPS Police Services. And I'm asking you to read paragraph B into the record.
Yes, my lord, I'm not actually, just to clarify, I'm not asking questions to counsel. I'm simply clarifying for counsel to know that this is not the only form prescribed.
Yeah, can you read paragraph B now?
Yes, counsel, if you can give me a chance.
Read
because
it.
Give me a chance, I need to answer, because I'm assisting the court. That impression must not be given that this is the only form prescribed.
I've never asked what you are saying. I've never asked what
Mr.
you are saying.
Mshololo, how are we going to proceed now? Like we're in a tavern now.
Apologies, ma'am.
This is a senior police. He's a brigadier. You ask him a question. He proffers an answer. Give him a chance to answer. He says the standing orders don't prescribe that form. And you are saying the South African Police Services prescribe that form. So maybe you should produce the law, both of you, not even both of you. Because he says there's no standing order which says, am I quoting you correct, sir?
Yes, I'm saying, my lord, there's no standing order that says this is the only prescribed form for taking a warning statement. And there is an authority that speaks to that, my lord.
My lord, I
Okay.
apologize
No, continue.
for interjecting the witness, my lord. But the witness, Brigadier, as a senior member of the police, he must understand that he is supposed to answer the question that has been put. He's coming with explanations which have not been invited or asked by myself, who is a cross-examiner in these proceedings.
My lord, my understanding, I'm here to assist the court, not to allow an insinuation that I can see it's misleading. All I said is that it is incorrect to say this is the only form prescribed by the ACPS. There are many forms. There's no specific form that says this is the only form for the warning statement. And I felt that must be made clear in the court. It was not meant to undermine or stop counsel, because it didn't come, from my understanding, I understood counsel to be saying this is the form ACPS prescribed for the warning statement, and I wanted to correct it, that is not correct.
Are you done?
Yes, I'm done.
Okay, can you comply with my instructions now? Read
which is
paragraph B.
the member who conducts the interview with the suspect has to complete this form fully in the presence of the suspect.
Umuntu iphoyisa eliyenza i-interview la buza khona umsolwa imibuzo kwamele agcwalise iform leli elichazwa la
Okay.
umsolwa
Paragraph C.
ekhona.
Sorry, my lord. Paragraph C.
If pages, the member must continue on a separate follow page. This follow must be signed by the member, suspect, interpreter, and the commissioner of oath, and must be attached to the statement.
Uma ingabe isikhala lapho asenelanga umuntu angasebenzisa elinye ipage ekwamele lisayinwe iwonke umuntu ozabe ekhona lapho umsolwa iphoyisa utoliki nalo ozabe exhifisa istep.
Yes. Paragraph D.
The commissioner of oath must sign on every page of the statement.
Lo oxhifisa istembe kwamele asayine wonke ama page.
Paragraph F.
If the suspect is a child,
Paragraph F.
paragraph F, all deletions must be initiated by the suspect.
Kusayindwe noma kwenziwe ama initials.
All persons present.
The names of all persons present during the interview must be recorded. This includes all members present, the parent of the child, or a legal practitioner.
I will pause here for now and then ask you to read paragraph 6.
Paragraph 6 must be deleted if no questions are put to the suspect. If the suspect indicates that he or she is not willing to answer any questions, this refusal must be recorded. In the space below paragraph 6, the suspect may thereafter not be questioned further.
Okay.
If, should I proceed?
Uqhubeka nalokho kwamele kumele zibhalwe lezo
D and C.
But not willing to make a, okay. If the suspect is willing to make a statement, but not willing to make the statement to the member,
Right.
if neither of these choices are acceptable to the suspect and he or she has another proposal, it should be recorded as E.
kwenziwe njani.
Into the record. 3, it's the copy available to the witness.
Yes, I have the copy, madam.
Then page 9 of the same transcript, line number 17. I'll read it out. Yes, so thereafter I have put, now I'm asking by the accused, mounted to a confession.
That is correct, madam.
Iqiniswa bone ukuthi ngathi usekazofuna ukugonyuluka uthi yebo.
Was that recorded anywhere in this form or in any document? Was it recorded?
Well, let's start with the form, my lord. I think I've explained that the form was not present at that time. It was an interview, basically the event. It's not like various statements it appears in the, but the form it was not completed.
Lento ayikhulumile iye yabhalwa na kule form leyana uthi cha ayibhalwanga.
Okay, and then let's go further on the same page wherein you say, I then asked him obviously after the discussion, my lord, as to whether, how did the accused become...
As it says here, my lord, I asked him that will he be, exactly as it says, I then asked him, obviously after the discussion, my lord, as to making a confession, and such confession in my view was being made freely and voluntarily. Now as for best practice rule, my lord, I prefer that an independent officer
and also
Zangaye ukuthi uzimisela ukuthi angayogunyuluka kumuntu ozimele ongekho la. Uthi ubrigadier ingalendlela ngicha ongekho la phakathi kwethu ula umangalela wathi yebo.
in other
Ebekade ayisho